अभी चलो.
Good evening.
Good evening. How are you, sir?
Very fine, thank you. You told me that it is sufficient that I enter at 5:45.
No. Okay. Good evening, friends. In our pursuit to have webinars on a different perspective, we have been connecting with the speakers who are having knowledge on different perspective of law and beyond law. As the topic speaks for itself, the group itself of the team of Beyond Law CLC means that we can have insights of law and beyond law, which could enrich any professional for his insights which are relevant for the purposes of growing in the life. Since we have been having topics connected with law, as well as which are, we can say, like master series or a series meant for practitioners or students of law. As the students of law, not only lawyers as well as students or judicial officers, would agree that evidence constitutes a vital part in one's growth in the legal profession as such. Amongst us, we had requested Honorable Mr. Justice K. Abraham Mathew, former judge of the Kerala High Court. He has already been on our platform, and his insights given on the topic have been well received, and therefore we requested him, because his insights on the topic are itself, as we say, looking at a picture on a two-dimensional or a three-dimensional has a different perspective. So once you read it and thereafter having an insight from a person who himself is an insightful person, is always more like a 3D view, which gives you the dimensions not only as what a student could understand or a person preparing for the judiciary or a judicial officer or a lawyer. His lordship was an additional director of Directorate of Training, which was renamed as Kerala Judicial Academy. And thereafter, he was also the director of Kerala Judicial Academy and had been posted as a Kerala Vigilance High Court of Kerala. His judgments are path-breaking and have been widely read, not only as for the purposes of law, but also it gives deep insight what was the background, why this principle while coming out to the judgment was derived, etc. As we all say that we are fortunate enough to learn these arts and nuances of documentary evidence. And documentary evidence, as we all know, further constitutes as primary and secondary evidence. And we are delighted, that is the Beyond Law CLC team and the participants, not only on the group, but also on the Facebook, to the effect that we will be having insights from him. The previous session, as I earlier said, has been widely received. And not only on this platform, wherever he has given insights on all the YouTube channels, they are going, as we say, all gun blazing. Over to you, sir, and thank you for accepting our invite.
Thank you, Mr. Vikas. Good evening, my dear friends. I am very happy to meet you again. And today's topic, documentary evidence. This is one of the most important topics under the Indian Evidence Act. Or I think this is one of the most interesting subjects also under the law of evidence. So we shall first start with this definition of documents. In the interpretation clause, section 3, in the Indian Evidence Act, it is defined as any matter expressed or described upon any substance by means of letters, figures, or marks, or by more than one of those means, intended to be used or maybe which may be used for the purpose of recording that matter. If you have the book with you, you just underline 3 words. That is matter. The second is substance. The third is a recording. And one more you may just add, means. Means. So these 4 words you may just underline. So the first question is, what's a document? How can there be, what may be the different nature of documents? So some illustrations are given. A writing is a document. Words printed, lithographed or photographed are documents. A map or a plan is a document. An inscription on a metal plate or stone is a document. We know that as tombstone, a milestone. These are all documents. A caricature is a document. Suppose there is a rock or a rocky mountain between the boundaries of two villages in a district. How can the boundary be demarcated? In our state, what is used to be done was to make boundary mark on this rock. So this boundary mark becomes a document. So we have noted these three words or four words, that is a matter, substance, means, and record. So at least two things are necessary to make a document, to constitute a document. The first is a substance. There should be a substance. Substance is something which has a physical existence. Which has a physical existence. Then there should be a matter expressed or described upon it. So any matter expressed or described upon a substance becomes a document if it is made by any means which is intended to be used to record the matter, record that matter. This is actually the definition. So I shall just give you an interesting example so that you may not forget it. In our locality, there was a very, very rich man. Very, very rich man. He had only one daughter as a child. The only child is a daughter. She was 18 years old. In the neighborhood, there was a very poor boy. He was very, very poor. So conscious of the fact that, or realizing the danger posed by these two facts. One, the daughter is very beautiful. The other is the man is very, very rich. So there is a danger in it. He realized it. So he never allowed this girl to go out. This boy actually fell in love with this girl. But there was no means for him to inform the girl about it, because communication was impossible. So one day it so happened that a cow from the rich man's house strayed into this poor boy's property. Then this boy thought this is the golden opportunity for him. So what did he do? On the cow he painted, "I love you," so and so, boy's name. In the evening, this cow went back to the rich man's house. The rich man saw it. There was a litigation. What is the significance of this cow? See, going by the definition, there is a matter, that is, "I love you," the words. It is expressed upon a substance, that is the cow. So far as the definition is concerned, this cow has become a document. So any matter expressed upon any substance, it becomes a document. This is the definition of document. Trees have been held to be documents. Suppose some trees are auctioned by a company and these trees are marked. Then this marking becomes a matter and it is expressed upon the substance, namely trees. That has been held to be, the trees have been held to be documents. So some doubt may arise. What is the meaning of this phrase? For the purpose of recording the matter. For the purpose of recording the matter. In other words, we can read the whole definition. Document means any matter expressed or described about any substance by means of letters, figures, or marks, or by more than one of those means, intended to be used or which may be used for the purpose of recording that matter. So the phrase or the expression which is intended to be used or may be used relates to which word or which phrase? Does it relate to substance? Should it be a substance on which something should be recorded, just like a paper or a board, something like that? Or does it relate to the matter? So the answer is neither. The phrase intended to be used or which may be used, it does not relate either to the substance or to the matter. It actually relates to the means. So if the means used by the person is one intended to be used or which may be used to record the matter, then it is a document. So that is the meaning of the phrase which is intended to be used or may be used. It relates to the means which is employed to record the matter. That's all. Now we know that there are two types of documents classified into two. They are public documents and private documents. So let us go to section 74. Section 74. The following documents are public documents. Documents forming the acts or records of the acts of the sovereign authority, of official bodies and tribunals, and of public bodies, public officers, legislative, judicial, and executive of any part of India, or of the Commonwealth, or of a foreign country. It does not create any problem for us, clause 1. But when you come to clause 2 says, public records kept in any state of private documents. I think this is the most difficult clause in the Indian Evidence Act for interpretation. It's very difficult to, or there is no proper explanation for this clause in the Indian Evidence Act, any commentary or any judgment. So we know that a party may file, a person may file documents before a public servant, just like a plaint. A plaint is filed in a court. So it is a public document, it is a private document. Once it is filed, does it become a public document? Take another case where a document is presented to the sub-registrar or registrar for registration, like a sale deed, a mortgage deed, or gift deed, or lease deed, something like that. Does it become a public document on its registration? I think nobody has any doubt that the sale deed or the registered any other document, it is not a public document. The reason being that the document is not kept in the office of the sub-registrar or registrar. After its registration, it is returned to the party. So the document is with the party, that's a private person. So there cannot be any doubt that registered deeds or documents in the possession of, in the custody of parties are not public documents. The first decision on the point is, that is AR 1943 Privy Council, Year 1943 Privy Council 83. This is the one approved by the Supreme Court also. The Privy Council decision was approved by the Supreme Court. So it is a settled law that registered documents in the custody of the parties are not public documents but private documents. But in the sub-registrar's office or from the sub-registrar's office, you get certified copies. Then is it a public document? The copy kept there. The copy of the registered document which is in the custody of the sub-registrar, is it a public document? That is the question. The Privy Council apparently took the view with the very same decision that is not a public document. But on the other hand, there are several decisions of various high courts in India after independence that they are public documents. Means the copies of the registered documents kept in the office of the sub-registrar are public documents. The two decisions which we may notice are one of Madhya Pradesh High Court, AR 2006 Madhya Pradesh 107, a division bench. The judgment was written by Justice Ravindran, who later became the judge of the Supreme Court and judge of the Supreme Court. It was followed by a learned single judge of the Kerala High Court in 2017, Volume 1 KHC, Kerala High Court cases, 57. So these decisions hold that the copies of the documents, registered documents kept in the office of sub-registrars or the registrars are public documents under clause 2 of section 74. Section 74. Now there are several decisions holding that private documents like pleadings are not public documents. Once a plaint is filed in the court takes it on file, it is numbered, then does it become a public document? A public document. Say there is one decision of the Supreme Court which has taken the view that once the pleadings are taken on the file of the court, they become part of the records of the court. They become part of the records of the court. The decision is 2002, Volume 2 SEC 445. I think on the basis of this judgment, we can say that once a private document is made part of a public office, it becomes a public document. It becomes a public document. I think that is logical. That is logical. The Supreme Court has said that as it becomes the property or the record of the court, a party cannot come and make amendments in it without the permission of the court, because it has become the property of the court. That is why for amendment, you have to take leave of the court. You cannot even make any mark on it unauthorizedly, saying that this is my document, this is my plaint, so I have the right to do it. No. The decisions I mentioned, the second decision is 2017, Volume 1, Kerala High Court cases, KHC 57. Yes. The Supreme Court decision is 2002, Volume 2, SCC 445. Okay. So, right. Now the question here is there any difference? See the words used. Public records kept in any state of private documents. So, two words have been distinctly used. One is a record and the other is documents. It surely shows that their meanings are different. The words a record and document used in section 74 clause 2 signify different meanings. They denote different meanings. So a record may be a record of certain events that took place in the public office. It may be in the form of a book. It may be in the form of a file. It may contain private documents. It may contain private documents. So, if it contains private documents, like an application or a petition submitted by a citizen, and it forms a part of the records of that public office, it should be held as a public document. In other words, collection of private documents forming a record of a public office are public documents. That is why I cited the Supreme Court decision, how a private document becomes a public document. Now the question here is, as held by the Madhya Pradesh High Court and the Kerala High Court, whether a copy of a document becomes a public document. To answer this question, we have to understand the meaning of the word document. In what sense the word document is used, not this definition clause, but in what sense the word document is used in the Indian Evidence Act. I may say that in the Indian Evidence Act, the word document is used in the sense that it is original document. Only an original document is called document in the Indian Evidence Act. So in any section or clause, if you see the word document in the Indian Evidence Act, you must immediately add or prefix the word original before the document. So only an original document becomes a document under the Indian Evidence Act. Support may be, you can have support from various sections of the Indian Evidence Act. Just to see section 61. What does section 61 says? Say, the contents of documents may be proved either by primary or by secondary evidence. Now section 62. Primary evidence means the document itself. So there can be only one document. The document itself, that means the original document produced for the inspection of the courts. So only an original document is called a document. Now the next section, you may notice section 63. Section 63 clause 5. Secondary evidence means and includes oral accounts of the contents of a document given by some person who has himself seen it. See the illustration D. Neither an oral account of a copy compared with the original, nor an oral account of photograph or machine copy of the original is secondary evidence of the original. So only a person who saw the original document can give oral account of its contents. This was so held by the Privy Council in AR 2007, AR 1927, Privy Council 16. Now you come to section 91. Section 91. When the terms of a contract or of a grant or of any other disposition of property have been reduced to the form of a document, and in all cases in which any matter is required by law to be reduced to the form of a document, no evidence shall be given in proof of the terms of such contract, grant, etc., etc., except the document itself or secondary evidence of its contents. So there is one document, that is the original document. That is called a document. Others are called secondary evidence. Copies are called secondary evidence. Now again you come to section 144. Another section. Section 144. Any witness may be asked while under examination whether the fact he is going to state is contained in a document. Then adverse party may object to oral evidence being given until such document is produced or until facts have been proved which entitle the party who called the witness to give secondary evidence of it. So document and copies and oral accounts are termed as secondary evidence. Only the original document is called a document in the Indian Evidence Act. If that is true, section 74 clause 2, what does it say? We shall again read it. The first part, the following documents. Documents here means what? You read it as original documents. So only original documents can come under section 74. Clause 2, public records kept in any state of private documents. So section 74 contemplates only original documents as documents. These sections clearly show that only an original document is called document by the Indian Evidence Act. And copies or oral accounts are called secondary evidence. Secondary evidence. So if that is so, if that is correct, then the decision of the Madhya Pradesh High Court and the Kerala High Court cannot be held to be valid, in my opinion. Because no court has considered the meaning of the word document used in the Indian Evidence Act. It can only mean original document. So any decision which says that a copy of a private document kept in the office of a public servant is a public document is patently wrong. Patently wrong. And another logic also is behind it. When a document is registered and the document is returned to the party, the sub-registrar's office retains a copy of that document. It is not even signed by the parties. A copy of the document is retained after comparison. But its certified copies are issued and they are marked. They are admissible in evidence. Why? They are admissible in evidence because there is a special provision in Section 57 Evidence Registration Act, that is subsection 5, which says that any certified copy issued under Section 57(1) of the Act may be given as evidence in a case, in a court. So, Section 57(1) of the Registration Act empowers the custodian of the document to give certified copies from the copies retained there. So, there is an empowerment under Section 57, subsection 1, that for issuing a copy of the copy, certified copy of a copy, and subsection 57 says that such certified copy may be used as evidence in a court. If that copy, actually the copy retained by the sub-registrar is a public document, it was unnecessary to incorporate Section 57, subsection 1 or subsection 5. Though it stands to reason that as a copy is not a public document, special provisions have been made in the Registration Act to give a certified copy of that copy and to use it as evidence in a case. I hope you have followed it. You have found the logic in it. So, in my opinion, a copy can never be called a document under the Indian Evidence Act, and Section 74 uses the word documents in the sense that original documents. No copy can be called a public document under any circumstance. So now we will come to the other provisions relating to documentary evidence. See, documentary evidence is defined. We shall come to it. What is the basis on which a judgment is pronounced? What is the basis on which a judgment is pronounced? It is not stated anywhere. It is not stated anywhere except Section 165, that is in a different context. That is in a special context. So we need not look into it. But it can be seen from the definition of proved, used in Section 3 of the Indian Evidence Act. A fact is said to be proved when, after considering the matters before it, the court either believes it to exist or considers its existence so probable that a prudent man ought, etc., etc. So, on the basis of proved facts, a court pronounces judgment. Not only evidence, matters before the court. A judgment is pronounced not only on the basis of evidence, but other matters also may be taken into consideration, because we know that under Section 30 Evidence Act, confession of a court case is no evidence. But that can be taken into consideration. The section itself says, then any answer given by an accused under Section 313 CRPC, that also can be taken into consideration, though that is not evidence in the case. The local inspection made by a court, a material object can be taken into consideration. Then presence or absence of a party, that also can be taken into consideration. That is why we pronounce ex parte judgments. The absence is taken notice of by the court. It's a matter before the court. We do not examine bench clerk or any other person, plaintiff's advocate, to prove that the defendant is absent. It's a matter which the court can take notice of under Section 57. It happens before the court. So we can say that mainly on the basis of proved facts, the court pronounces judgment in a case. Judgment in a case. So that takes us to the question, what can be proved in a case? What can be proved in a case? Only facts Section 5 declares that evidence may be given only of facts in issue and facts which have been declared relevant by the Act. That means only facts in issue and relevant facts can be proved in a case. Then the next question is how these facts can be proved, or what is the means of the proof. We get the answer in the definition of evidence. Evidence means and includes all statements of which the court permits or requires to be made before it by witnesses in relation to matters of fact under inquiry. Such statements are called oral evidence. That means a witness's statement in the court. Clause 2, all documents, including electronic records, produced for the inspection of the court. So this is called documentary. Such documents are called documentary evidence. Now you may ask me a question. If original documents are not documents under the Indian Evidence Act, how can a fact proved by secondary evidence be called documentary evidence? It is a reasonable doubt. The thing is that when you prove the contents of a document by secondary evidence, what you prove is the contents of the original documents. So by that means, the original document itself stands proved by that process. That is why this section says that the documentary evidence is the documents produced for the inspection of the court. Then the next question is, can any fact be proved by oral evidence? Can any fact be proved by oral evidence? Now we come to section 59. Section 59 says that all facts can be proved by oral evidence except the contents of a document or electronic records. So any fact other than the contents of a document can be proved under section 59, under the Indian Evidence Act. In other words, section 59 declares that contents of a document cannot be proved by oral evidence. Adducing oral evidence to prove the contents of a document is prohibited under section 59. This is further strengthened, this view is further strengthened by section 144. Section 144, once I read, it says that if a witness, it provides that if a witness deposes that the statement he is about to make, that the evidence he is going to take, the oral evidence he is going to give, is the contents of a document, that means that there is a document. There is a document with regard to the very same subject I am going to depose. Then, if objected to by the other party, oral evidence cannot be given. Oral evidence cannot be given. The party should produce the document itself. So oral evidence is excluded. Oral evidence is excluded. If a fact is a fact, it is a matter, it is a contents of a document. It is a contents of a document. But there is an exception. That means it is if it is a document which need not be produced. Need not be produced. We know that for contradiction under section 145, the party need not produce that document earlier. It is sufficient that he uses it in the cross-examination. That's all. So that is why it is said that if the court thinks that it ought to be produced, should be produced. Should be produced means it should be produced if it is a criminal case along with the complaint or the final report, or later with the permission of the court, or if it is a civil case along with the plaint, or at least before the issues are cast, or with the permission of the court later. So they are the rules. So such a document, the contents of such a document, which should have been produced by the court, cannot be proved by oral evidence. So now the next point is, how can you prove the contents of a document? How can you prove the contents of documents? Section 64 declares that the contents of the document may be proved. Sorry, section 61 declares that the contents of a document may be proved either by primary evidence or secondary evidence. The contents of documents may be proved either from primary or secondary evidence. Secondary evidence. And section 64. Again, you come to section 64. Section 64 reads thus: documents must be proved by primary evidence. By primary evidence, except in the cases hereinafter mentioned. So exceptions are given. So the ordinary rule with regard to the proof of contents of a document is that it should be proved by producing the original document. That is the ordinary rule. Then, primary document is defined as the document itself. That is the original document. Again, and I tell you that the word document, wherever it is used in the Indian Evidence Act, means original documents. Original documents. Just like when you say that, use the word judge or a judicial officer, you need not use is an honest judicial officer, because every judicial officer is supposed to be honest. If he is not honest, he cannot be a judicial officer, a judge. So it need not be stated that he is a honest judicial officer, because he should be honest. Just like that. Document means original document under the Indian Evidence Act. So primary evidence. Primary evidence is the document itself. Now, there may be three situations. There may be three situations when we consider this as primary evidence. The first situation is several original documents come into existence by a uniform process, like printing, then lithography, photography, etc. So, any uniform process, you take, I want to forget this computer, forget the computer. I want to write a letter. I have to take 4 copies also. What will I do? Or in the earlier period, what we used to do? We will use 4 carbon papers and we'll type it. And 5 copies, 5 documents come out of the typewriter. So they are all prepared or made at the same time by a uniform process. By a uniform process. If that is so, all these 5 documents are original documents, because it was made by a uniform process. So a document, several documents made by a uniform process, like printing, typing, lithography, photography, etc., are original documents. Though in physical appearance, except one, the others are carbon copies. In the eye of law, under the Indian Evidence Act, they are not copies, they are original documents. If you prepare a receipt in duplicate using a carbon copy, then the original as well as the carbon copy, both are primary evidence. Both are primary evidence. Suppose a police officer, an incident takes place. A criminal case was registered. And immediately thereafter, A counter case also was registered on the basis of the information given by the accused in the first case. Accused in the first case. So the police officer knows that there is a case and a counter case. Yes. There is a case and counter case. So when the police officer prepares the Panjanama, he knows that two Panjamanas are necessary. One in the original case, the other in the counter case. So he does one thing. He prepares the Mahasar in duplicate using a carbon paper. Using a carbon paper. So one is produced in the original, which in physical appearance, the original that is produced in one case, and the other carbon copy is produced in another case. When this carbon copy is tendered in evidence, the defense object its marking on the ground that it's only a carbon copy. It's only a carbon copy. So what can be the correct view? This under section 62, this also is an original document. This is also a primary evidence. That is explanation 2. AR 1989, Supreme Court 702. But there may be instances where from a common original, several copies are made by a uniform process. Yes, right. By a uniform process. Take a case. I or an advocate prepares a pledge. Then he gives to a typist. Take 5 copies. The typist takes 5 copies at the same time. So we have already seen that if it is made by a uniform process, all are primary evidences. But here, it is not the original one. The original one is the one the advocate gave the typist. It is look on the basis of that original, these 5 documents are made. So there is a common original for all these 5 copies, which were prepared by a uniform process. Then the 5 are not considered primary evidence because there is a primary evidence by the common original is the primary evidence. But so far as the 5 copies taken together simultaneously, they are considered each of those documents is a primary evidence of the rest. Because of this explanation, it is easy to prove the defamatory statements published in newspapers by producing any paper. In defamation cases, this can be made use of. Otherwise, what is necessary? You have to summon the original from the paper wala. That is not necessary. Now, this is the explanation 2. Now we come to another situation. Several documents, identical, the very same documents, identical, may be made by different processes, not by a uniform process. Take a case where there is a receipt has to be given. There is a counterfoil also. So you write on the counterfoil. Thereafter you write this other part. So both are identical, signed by the same party. You tear off that this document meant for the party and gives it to him. So 2 identical documents, they are not prepared by a uniform process. This happens in duplicates, triplicates, prepared separately. prepared separately. We know that in treasuries, I don't know how it is in North India, but in Kerala, treasuries challenge. When you want to pay money into the treasury, you have to prepare this document in triplicates. All are identical copies. One will be retained there, one will be given to us, one used for some other purposes. So this is actually each one is considered an primary evidence. That is explanation 1. Explanation 1. Here the difference between explanation 2 and this part is that this is not made by a uniform process, though they are identical documents, but they are made by different separate processes. I completed one for the original, then I completed the duplicates, then I completed the triplicates. I signed each one. Identical documents, but they are made separately. Each one is considered the original one, primary evidence. Then another one situation is where a document, this is explanation 1, where a document is executed in counterpart. Each counterpart being executed by one or some of the parties only. Each counterpart is primary evidence as against the parties executing it. Say, what is the meaning of it? I don't know whether you have seen. We can just imagine this agreements between two countries. That is a MOU, Memorandum of Understanding. Memorandum of Understanding is an agreement between two parties, by two countries. Suppose it is between Germany and India. Then German ambassador comes here or foreign minister comes here. Indian foreign minister also is there. They come to an agreement. The two countries come to an agreement. Then an MOU is prepared. After that, you must have seen, you must have watched on TV what they do. One file will be handed by the Indian foreign minister to the German foreign minister. German foreign minister will hand over one to the Indian foreign minister. The very same documents. Suppose the German foreign minister has signed, or he alone has signed the documents he handed over to the Indian foreign minister, and the Indian foreign minister has signed only the one he handed over to the German foreign minister. Though they are identical documents, we can say that they are counterparts. They are counterparts. In other words, though it is one and the same document, it is not signed by both parties. One document is signed by one party, the other is signed by the opposite party, the other party. And one party the one party who signs the document hands it over to the other party, and vice versa also. Then the document signed by one party becomes a primary evidence as against that party. So the memorandum of understanding signed by the Indian foreign minister, which is in the hands of the German foreign minister, is a primary evidence against India, and vice versa also. This is the difference. Explanation 1. I hope you have followed it. Then, so we have seen primary and primary evidence. Then, for a document to become evidence in the case, we are dealing with documentary evidence. For a document to become evidence in the case, what is necessary? We have seen the definition documentary evidence. I shall read it again. All documents including electronic records produced for the instruction of the court. Does it mean that mere production in a court, in a case, will make that document an evidence in the case? That's the question before us. A mere production, because what is stated in this definition is that document produced for the inspection of the court. If it is produced, the court can read it. Does it become an evidence in the case? Documentary evidence? No. The word or the phrase for the inspection of the court, it has a technical, it is used in a technical sense. It means only when it is made a part of the evidence in the case, the court can inspect it. Its meaning is this. Only if a document is made part of the evidence in the case, it becomes, or the court is entitled to inspect it. Otherwise, it may be there. The court cannot read it and pronounce a judgment. So the purpose of taking a decision, only if that document is made a part of the evidence in the case, it will become documentary evidence. Mere production is not sufficient, because a document cannot prove itself. A document cannot become evidence without evidence being given in respect of it. AR 1989 Supreme Court, AR 1989 Supreme Court, 201. (2006), Volume 12, SEC 321. Right. 2013, Volume 9, SEC 209. Right. So a document cannot prove itself. How can you make it part of the evidence in the case? A marking of the document or production before the court, that does not make it a part of the evidence in the case. To make it evidence in the case, you have to you can make a document part of the evidence in the case by a process known to law. Only by a process known to law, you can make a document part of the evidence in the case. What are the processes known to law to make a document part of the evidence in the case? The first is you tender it and prove it through a person competent to prove it. Tender it through or prove it through a witness who is competent to prove it. That means oral evidence is given with regard to the proof of the document. Then second one is by the admission of the parties. By the admission of the parties. Section 58 Evidence Act, admitted fact need not be proved. So there you need not to prove execution of the document. And there is another process, that is by a statutory declaration. By a statutory declaration. There are certain statutory declarations to the effect that certain documents are part of the evidence of the case. The classic example is in civil cases, Order 26 Rule 10 CPC. Order 26 Rule 10 CPC declares that a report of a commissioner is part of the records of the case. You need not examine the commissioner. It need not be tendered in evidence. But courts usually mark it only for reference to remind the court, that there is such a document. Or otherwise, even marking is not necessary because of the statutory declaration, it has already become part of the evidence in the case. Then similar provisions in CRPC, sections 292, 293 CRPC. So these are the three processes known to law to make a document part of the evidence in the case. And there is no other way by which you can make a document part of the evidence in the case. This is applicable even to a public document or its certified copy. I say this because we can come across certain decisions even of the Supreme Court saying that since it is a public document, it can be looked into. No. Document can be looked into or the court can inspect it only when it is made part of the evidence in the case. And the court can be made part of the evidence in the case only by the three processes I have already mentioned. There is no other fourth way. Fourth process is there. So now we come to section 67. 67 in effect says that you can prove the contents of document by proving the handwriting or signature of the person who allegedly did so. You have to either prove the signature or the handwriting. Why they are used differently? Why they are used differently? They are used differently because some documents may not contain the signature of the party, signature of the author. Suppose I write a letter to my friends. I forgot to sign it. It does not mean that I am not the author of the document. It is sufficient that the party proves my handwriting. Then there is another situation where the letter is written by me and it contains my signature. Then it is sufficient for the party to prove the signature alone. He need not prove the handwriting and the signature. Then there is a third situation where I got it written by another person, that is, I dictated to the person, and he wrote it, and I only signed it. As I signed it, I become the author of the document, not the person who wrote it. This is the reason why these two words are used distinctly in section 67, handwriting or signature. And we know that signature includes thumb impressions also. Immediately we shall jump to another question. It is this: how can you prove handwriting or signature of a person? How can you prove it? There are different methods of proving handwriting or signature. The first one is by the evidence of the person who wrote it. He enters the witness box and deposes that, yes, I wrote it, this is my handwriting or signature. That is the first one. The second one is by examining a person who saw the author writes it or signs it. Suppose a check is given in evidence by the complainant in a complaint under section 138 NIH. He deposes that this is the check given by the accused to me. Does it prove execution of the document? He only deposes that this is the check the accused gave me. That will not prove. Then how can he prove it? The accused will not enter the witness box. So the person who allegedly wrote it cannot prove it. The second is, any person who saw it saw the accused write it or sign it. Because it is a signing or writing of a document is a fact which can be seen. And if it is a fact which can be seen, evidence has to be given by the person who saw it under Section 60 Evidence Act. Under Section 60 Evidence Act. It is Section 60 that applies in that situation. And these two options are not available for us. Suppose. Then there is a third means to prove handwriting or signature. It is by proving the admission of the person who allegedly wrote or signed it. By the admission of the person who allegedly signed or wrote it. That is under Section 21 Evidence Act. Then, if that also is not available, then by the opinion of experts in handwriting under Section 45, evidence of an expert in handwriting, Section 45. Then there is a last option for the party, that is by the evidence of a person who is acquainted with the signature or handwriting of the person who allegedly wrote it or signed it under Section 47. And there is yet another method, that is, if the party has an admitted or proved signature of the person who allegedly wrote it or signed it, produce it before the court, so that the court may compare the admitted or proved signature with the disputed signature or handwriting under Section 73. Under Section 73. You can profitably read AR 1979 Supreme Court, 79 Supreme Court 1-4. So now we have proved the documents. It has become a part of the evidence in the case. It has become documentary evidence in the case. Right. Now, what is the probative value of it? What is the probative value of it? See, if the truth of the contents it is necessary to prove the contents of the document, mere marking of the document, mere making it a part of the evidence in the case, does not serve the purpose if the truth of the statement in it is disputed. It has to be proved, the truth of it has to be proved, the contents of the document has to be proved by other evidence, by a person who is competent to prove its truth. So the proof of a document or the contents of a document and the proof of the truth of the contents are different. AR 1981 Supreme Court 2085. There are other decisions also. Several decisions are there. Suppose I am a public servant. I am a public servant. 81 Supreme Court, not 85 Supreme Court. This is AR 1981. 81. Right. Suppose I am a public servant. And when I come out of my office on a day, on a particular day, some people stand before this my office with some placards showing that Mathew is a corrupt officer. is a corrupt officer. So several people are there with these placards. I file a defamatory suit or a case, criminal case. So it is necessary for me to prove that they are displayed these placards. Does it mean that I prove the truth of its contents? Then there is no case for me. If that is true, how can I prove? How will I produce it? No, I will not go for a case. So, truth of a case, proof of a document, and truth of the contents of the document are entirely different. There may be cases in which the truth of the statement has to be proved. There may be cases where it is not at all necessary to prove the truth, but it is sufficient to prove that there is such a document. And the opposite party is the author of that document, just like this defamatory suit. Now we are coming to a question whether proof of a part of a document is allowed. And we all know that a part of a document cannot be admitted in evidence. The ordinary rule is that only a complete document can be admitted in evidence. If a document consists of 5 pages, the party must produce 5 pages. It cannot be marked. A part cannot be marked. It cannot be admitted in evidence. Okay. But there are some exceptions. Section 35 Evidence Act says that if it is relevant in a case, that is only an entry in a public office, public record, or other official book, public record or other official book, alone is sufficient, and that because it is that alone is relevant, then it is necessarily sufficient for the party to prove that entry alone. That entry alone. Then we shall rush to section 39. Section 39 says that if only a part of a statement, conversation, or isolated document, or a book, or connected series of papers, it is sufficient for the party to prove that part alone, if that is relevant. Suppose a part alone, only a part of a statement is relevant for a case, or a series of papers, only one paper is sufficient for me to prove, then it is sufficient for me to prove only that part. Section 39. Now the question is whether a part of a document can be certified copy of a part of a document can be given. Yes, whether a part of a public document can be given, certified copy of a part of a document can be given. Section 76 says that, I shall just bring to your notice that particular provision. Section 76. Every public officer having custody, etc., etc., at the foot of such copy that is a true copy of such document or part thereof. Or part thereof. So, suppose an admission register is maintained by a government school, and only one page relates to my child. The entire book becomes a document. But it is sufficient for me, it is relevant, only the entries relating to my child is relevant for me, and I need proof only that document under section 39. So section 76 empowers the custodian of this document to issue that part alone. So we call it certified extract. That is the phrase used in Kerala. I don't know how it is in the other parts of the country. We say that this is a certified extract of a public document. Section 76. Section 76. We can see the words used, part thereof. A true copy of such document or part thereof. So these are the situations in which a part of the document can be proved. Now we come to secondary evidence. Secondary evidence. Section 63. Section 63. Section 63. Section 63 runs thus. Secondary evidence means and includes. What is the meaning of this means and includes? Means and includes means it is exhaustive. It is exhaustive. In other words, you cannot add anything to it. You cannot delete anything from it. But you see some decisions of certain high courts to the effect that it is not exhaustive. There can be other forms of secondary evidence. There are forms of secondary evidence other than those mentioned in section 63. There are some high court decisions, but they are not good law in view of AER 2007 Supreme Court, AER 2007 Supreme Court, 1721. 1721. Okay. Now the first clause, certified copy is given under the provisions herein contained, hereinafter contained, hereinafter contained. So there are provisions in the Indian Evidence Act to issue photocopy, issue certified copies. We have already seen section 76, section 76, and they are certified copies of public documents. And always remember that a certified copy can be given only by the custodian of the original documents. Original documents. Because the definition in section 76 says so. It runs thus. Section 76. Every public officer having the custody of a public document. Here also you see custody of a public document. That means the original documents. The original documents shall be given on demand, etc. So only if the public servant is in custody of the original document, a certified copy can be given under section 76 of the Evidence Act. A certified copy of a copy cannot be given, but it may be given under some other acts, Right to Information Act. Then, can certified copies of documents other than public documents be given? Section 78 Evidence Act enumerates certain documents of which certified copies can be given. Then they are all public. They are all documents related to public offices. Then can certified copies of private documents be given? Have you ever heard of certified copies of private documents admitted in evidence? You can just think of it. Yes, certified copies of private documents are also admissible. Some examples I can give you. Under Section 2 of the Bankers Books Evidence Act, private bank, HDFC Bank, ICICI Bank. The banker is allowed to issue certified copies of bankers' books, cash books, ledger, etc., etc. They are private documents. Still, their certified copies are admissible under that act. Then, as we have already seen, Section 57(5) of the Registration Act. Section 57, subsection 5 of the Registration Act. Though the document is a private document, because I have already told you that a copy retained by the SRO is not a public document. The original is the document that is in the custody of the party, and copy of that copy is permitted under Section 57(1), and it is made admissible under Section 57(5). Then the recent one, Section 65 capital B Evidence Act. Section 65B capital B Evidence Act. So copies of certified copies of public private documents are also admissible. So I think I need not elaborate on this certified copies of documents permitted under this Evidence Act. Now, clause 2, Section 63, clause 2. You have to listen carefully. Copies made from the original by mechanical process, which in themselves ensure the accuracy of the copy, and copies compared with such copies. So clause 2 has two limbs, or it deals with two situations. We shall consider the first situation, the first limb. Copies made from the original by mechanical process, which in themselves ensure the accuracy of the copy. See, copies can be taken not only from this original, but copy may be taken from copy also. You take a copy, photocopy, take a photocopy from that photocopy. So here it says that copies made from the original by mechanical process, which themselves ensure the accuracy of the copies. So conditions are there. The classic example is photocopy. And in that case, if it is obtained by a mechanical process, no comparison is necessary with the original. No comparison of the photocopy with the original is necessary, because the mechanical process itself guarantees the correctness of the copy. Now we come to the second limb in clause 2. Copies compared with such copies. Copies compared with such copies. So you take a photocopy from the original. Another person take a photocopy from your photocopy. So the photocopy of the third man is not made from the original, but from your photocopy. That means a copy of a copy. But here comparison is necessary. But comparison need not be with the original. The comparison, it is sufficient that it is compared with the photocopy. That is the situation here. Okay. Now clause 3. So as a rule, we cannot say that a copy of a copy is never admissible in evidence. Clause 2 permits it. Clause 2 permits it. Then clause 3. Copies made from or compared with the original. So this also has two limbs. The first limb is copies made from the original. It is to be understood that it is not by a mechanical process, because if it is by mechanical process, clause 2 will apply. So it does not contemplate a copy, a copy taken by a mechanical process, by other means. So if I make a copy on the basis of the original, that means I am making a handwritten copy of from an original. Then comparison is not necessary. Comparison is not, because I made it from the original itself. So copies made from the original by any process other than a mechanical process, also comparison is not necessary. But the second situation, copies compared with the original. So I make a copy from the original, or I make a third party. A third party makes a copy from a copy. He copies it, a manual copying he does. He writes it, or types it. Then it is not from a copy. Sorry, it is not from the original. That man made a copy from a copy. Then that should be compared with the original. That should be compared with the original. That is why it is the copies made from or compared with the original. So whatever may be the means by which you made the copy, it should be compared with the original then. So here also a copy of a copy is admissible. Then counterparts or documents asked against the parties who did not execute them, we have already seen. Against a party who signed it, it will be a primary evidence. But so far as the other party is concerned, it is a secondary evidence. Secondary evidence. Then 5. And regarding that clause 3, second limb, you may note down certain decisions. One important decision is AR 1989 Patna. AR 1989 Patna 96. Now clause 5. Oral accounts of the contents of a document given by some person who has himself seen it. Who has himself seen it. I mentioned it when I said that a document means original document. It follows that a person who himself cannot read a document cannot give oral accounts of it. Suppose a person is blind, he cannot read it. Another person reads out that the contents of the document to him. He only hears it. Then clause 5 is not applicable. Suppose that person is illiterate, he cannot read it. Then clause 5 is not attracted. AR 1927 PC 1616. Right. Now this appears to be like an exception to section 59. Section 59, we have already seen that says that all facts except the contents of a document can be proved by oral evidence. Here, an oral account of a person who has seen it is admissible as a secondary evidence. Okay. Now we come to section 65. Section 65. We have seen that under section 64, it provides that documents must be proved by primary evidence. Primary evidence. That is the ordinary rule. That is the ordinary rule. But there are some exceptions given in section 65. Section 65. Section 65 version. Section 65, as it is very late, I don't think that it is advisable to read the parts. To read this parts. Okay. But I may tell you that section 65 has two parts. Section 65 has two parts. The first part mentions the situations in which, or the facts which would entitle a party to adduce a secondary evidence. The first part of section 65 gives or mentions the facts which would entitle a party to adduce a secondary evidence. The second part says that, or gives us, mentions the particular kind of secondary evidence which may be adduced in each situation. So there should be a matching. There should be a matching. We know that these ladies go to textile shop. Suppose a lady wants to purchase a sari, then she would go there, ask the salesman to take out all these 1,500 saris there. Then at last, she again wants to no, show this one, the other one, etc., etc. Again, he takes out 10 saris, and after 1 hour, she selects one. Then the husband who is with him has already grown impatient. He would say, "Okay, I will pay the bill. Come out." Then she would say, "No, no, no, no. I have something else to do." She wants a blouse piece, a piece of cloth for a blouse. Then she would go to the next salesman. Then what he would do, he would take this sari and match it with each cloth there. Whether this shade is sufficient, that shade goes with it. This is the process given in section 65. Each clause in section 65, the first part of section 65, should match with each clause in the second part of section 65. In other words, we can say that there are different kinds of animals in this world. Human beings, we are all animals. Our sound is called, we talk, speak. Human beings speak or talk. But a monkey chirps. An elephant trumpets, a lion roars, a sheep bleats, a dog barks, a snake hisses. So a separate sound is made for each kind of animal. Likewise, a separate secondary evidence, type of secondary evidence is mentioned for each situation. So you cannot prefer, you cannot choose any of the secondary evidence mentioned in section 63 in every situation. For different situations, the law prescribes different types of secondary evidence. So let us see first clause A. Clause A. Clause A. When the original is shown or appears to be in the possession or power, you may read it. So here the original is in the custody of the opposite party. It's not available to the party who wants to produce it. Then you see clause C. When the original has been destroyed or lost. So it is not, it is lost in flood, it was stolen by someone, it was lost during journey, etc., etc. Then D, when the original is of such a nature as not to be easily movable, not easily movable, because it is a painting on a rock, it cannot be moved, it cannot be easily brought to the court. In these three situations, the second part of section 65 says, any type of secondary evidence may be given. Any type of secondary evidence may be given. So if it is a painting on a rock, you can take a photo. You can take a photo and produce it. Or a person who has seen it can give oral evidence of it. Anything. Any type of secondary evidence can be given. So also if it is destroyed or lost, then that is sufficient. Suppose it is destroyed. No document is, no copy is available. Then the party can, under clause 5 of section 63, give oral account. Oral account who has seen it. Then, if the original is in the possession of the opposite party, no prejudice will be caused to him. So you can give any type of secondary evidence, even oral accounts will be done. So in those situations, in these three situations, clauses A, C, and D, covered by clauses A, C, and D, any type of secondary evidence is permissible. Like our mimicry artist. They can make the sound of monkeys, they can make the sound of elephants, they can make the sound of dogs or donkeys. So anything. But when we come to clause B, when the existence, condition, or contents of the original have been proved to be admitted in writing by the person against whom it is proved or by his representative interest. So the plaintiff wants to prove a will. The plaintiff wants to prove a will. That will is originally is not available. According to him, it was stolen by someone at the instance of the defendant. This defendant brother denies the genuineness of the will. It is necessary to prove the contents of the document. The defendant brother had written a letter to a relative saying that, see, my father has disinherited me. He has not given even a single piece of land to me. He has given everything to my brother. He has gifted everything by a will to my brother. That contains an admission of the genuineness of the document, will. And the plaintiff can produce it. The plaintiff can produce to prove the contents of that document. Here he admits genuineness of the will. Here he admits that everything the father has gifted to his brother plaintiff. So that is the situation covered by clause B. Then you come to section clause E. when the original is a public document within the meaning of section 74. Any public document. Then you consider clause F also together. When the original is a document of which a certified copy is permitted by this act, a certified copy is permitted, we have seen, of public documents, and under section 86 some other some other documents also we have already seen. Then permitted by this act. Then what about the private documents? Private documents, see the next part of it, clause F. Clause F reads thus: when the original is a document of which a certified copy is permitted by this act, then or by any other law in force in India to be given in evidence. See the difference. So it may be a private document. If there is a law, there is a statute which says that a certified copy of a document will be given is an evidence in the case, then that is sufficient. That is sufficient. By Guest Books Evidence Act, section 57(5) of the Registration Act are examples. Now you see there is an act called Right to Information Act. It directs public servants or officers to give copies of certain information, or to give information or copies of certain documents which may be in the form of information. The question here is whether those copies are admissible under this provision. I don't know whether you have thought about it. This clause F says when the original is a document of which a certified copy is permitted by this act, Evidence Act, but here we have Right to Information Act, or by any other law in force in India. Right to Information Act is a law in force in India. But see the remaining part of the clause F. It says any other law in force in India to be given in evidence. So the statute should say that a copy issued under that statute can be given in evidence. It is not sufficient that there is a clause enabling a party to get a copy. The provision should say that it can be given in evidence. Like section 292 and 293 CRPC, 57(5) of the Registration Act. They say that it may be given in evidence. So if that phrase is not there, then it is not admissible. Such a clause is not in the Right to Information Act. So a copy obtained under the Right to Information Act is not a substitute for a certified copy, because there is no rule of evidence. There is no rule of evidence in the Right to Information Act. Then, so certified copies of public documents, certified copies of private documents, admissible under certain statutes. Then the second part of it, we have to match. In case E or F, where certified copies are permitted or available, then a certified copy of the document, but no other kind of secondary evidence is admissible. See, the only secondary evidence that is admissible out of the 5 that is mentioned in section 63, the only secondary evidence that is admissible where a certified copy is permitted given is a certified copy. No other clause is applicable. Only clause 1 is applicable in section 63. But there is one decision of the Supreme Court which says that section 65 clause A, that is if it is in the possession of the opposite party or etc., etc. Section 65 clause A is not controlled by section 65F. there is such a decision? It means that suppose all the public documents are lost and no copy is available, certified copy is available, then any type of secondary evidence is admissible. It is a very, very exceptional ruling. That is AR 1969 Supreme Court 253. Right. Suppose the sub-registrar's office is consumed by fire. Consumed by fire. All the documents were lost. The original is lost. No certified copy is available. Then section 65A may be invoked. That is all what the Supreme Court means. The decision means. Then G is the only clause that remains. G. When the originals consist of numerous accounts or other documents which cannot be conveniently be examined in court, and the fact to be proved is the general result of the whole collection. This is applicable. The classic example is, the question is, the fact to be proved is whether a particular company is running at loss or profits. That is the fact to be proved. That fact can be proved by the inspection of the account books of the company. But the accounts books of the company may be numerous. It cannot be conveniently examined in court. So in such cases, if there is a balance sheet prepared by a chartered accountant, then that is sufficient. That is sufficient. In case G, second part of section 65, in case G, evidence may be given as to the general result of the documents, that is account books, who has examined them, a chartered accountant who has examined them, and who is skilled in the examination of such documents. Chartered accountant is skilled in examination of accounts. So that is the classic example. Now, we have seen that clause A of section 65 provides that if the document is in the custody of the opposite party, etc., then secondary evidence of any type can be admitted in evidence. But section 66 says that in such situations, the party who wants to adduce a secondary evidence should give notice to the other party who is in custody of the original. Section 66. So suppose an agreement for sale is executed between the plaintiff and the defendant. The original is with the custody of the defendant, and the plaintiff wants to rely on it. The plaintiff should issue notice to the defendant to produce the original. Then only he can produce the copy of it and get it marked. If he does not produce it, the defendant does not produce. Okay, section 66. But there are some exceptions to it. The first exception is when the document to be proved is itself as a notice. Suppose an advocate issues a notice to the defendant. Original is always with the defendant. The advocate who issues cannot be in custody of the original. It is sufficient that he produces the copy, and the plaintiff need not issue notice to the defendant to produce the original. Then the other clauses are there. You may just go through it. That is sufficient. But we have seen that adducing secondary evidence is an exception to the rule that the contents of a document shall be proved by primary evidence. The ordinary rule is proof by primary evidence. The exception is proof by secondary evidence. So if it is an exception, a party who claims to be entitled to adduce a secondary evidence should prove his entitlement. A party who desires to adduce a secondary evidence should prove his entitlement to adduce a secondary evidence. This process is called laying the foundation for reception of secondary evidence. Proving the facts which would entitle the party to adduce a secondary evidence is called laying the foundation for reception of secondary evidence. So before this secondary evidence is given, the party should prove execution of the original, execution and existence of the original. So that's a condition precedent to adduce a secondary evidence. He should prove execution and existence of the original. Then the second condition, he should show why he is not able to produce the original documents. He should explain the non-production of the original. Explain the non-production of the original. Then the third one is, you should prove that it is the type, the secondary evidence you propose to adduce is the one which is mentioned in section 63 and in the second part of section 65. Right? So if it is a copy of a copy or it's a photocopy, you must prove that this is a copy taken from the original by a photocopy, from using a photocopier. How can you prove it? You prove, you examine the person who took the photocopy. Or if he is not available, if you saw the photocopy being taken, you must enter the box and say, I went to the photocopier shop and I saw the photocopy being taken from the original. So how this evidence has to be given, we can see. First, the party must examine the person who is competent to prove the original document. That means I saw him executing it, etc., etc. Then the next step is, you must depose that the original is not available because I have lost it. It is irrecoverably lost in a flood, in a fire accident, during my journey, in a theft case, etc. So you have explained the non-availability of the original. The third is, you just say, when I got the original, I went to a photocopier shop and in my presence I took a photocopy. And this is that photocopy. Or the other facts mentioned in section 63, we have a copy of a copy compared with the original, etc., etc. You have to depose. These are the requirements of section 65. You can read AER 1954 Supreme Court. (606) AER 1966 Supreme Court. 1457 1975 Volume 4 SEC 664. Volume 4 SEC 664. AER 2007 Supreme Court. Right. AER 2007 Supreme Court. 1721, two 2016, right, 2016, volume 16 SEC 483. Right. Now, there is an exception to it. There is an exception to the requirement that the party has to prove the original and explain the non-availability, etc., etc. That exception is with regard to certified copy of a public document. So in the case of certified copies of public documents, the party need not lay the foundation for reception of secondary evidence. The reason is this: Section 77 enables a party to do so, rely on a secondary evidence, certified copy. Section 77, such certified copies may be produced in proof of the contents of the public documents or parts of public documents of which they purport to be copies. This is the reason. But this does not mean that certified copies of public documents need not be proved by a process known to law. The execution, etc., of the original document, or it need not be tendered in evidence. It does not mean that a mere production of a certified copy of a public document will make it part of the evidence in the case. Because we have seen that a document can be made part of the evidence only by the process of three processes known to law. Mere production of a document in the case before a court does not make it part of the evidence, even in the case of a public document. But there are some decisions, even of the Supreme Court, which have taken the view that a mere production of a certified copy of a public document will make it part of the evidence in the case. That is wrong. You see Section 77. Such certified copies may be produced in proof of the contents. It only enables the party to produce it in proof of the contents. It does not dispense with the proof of it. So that means in the case of certified copies, the certified copy will be a substitute for the original. That is the only special concession made to certified copies of public documents. And no other exceptions given. No other privilege is there. Now, with regard to the photocopies, I shall give you some decisions. Already given, but in addition to that, you may just note down photocopies. AER 1968 Supreme Court. AER 1968 Supreme Court. 938. AR 1975 Supreme Court, 1748. 1748. Okay. 1991, Volume 3 SEC, 451. AR 1994, right. AR 1994, Supreme Court, 591. 591. Right. Okay, I shall just mention one more topic, and I think we will close it because it's already 7:38. See, we have seen that the definition of a document is that a matter expressed or described upon a substance that makes a document, constitutes a document. Suppose I execute a demand promissory note. Demand promissory note. And within 3 years, I make an endorsement in it that I paid a part of the amount towards the debt. So part payment is endorsed within the period of limitation. The suit is filed by the opposite party, by the person who lent me the amount, on original cause of action as well as demand promissory note executed by me. Original cause of action, you all know, when I take a loan, when a person takes a loan, there is an implied contract that he will return it. So, two causes of action. One is the original cause of action, which is the lending loan. The second is demand promissory note execution. It so happened that this demand promissory note did not bear proper stamps, sufficient stamps. So it was rejected in evidence. When my opposite party entered the witness box and he tendered it in evidence, I objected to it on the ground that it is not sufficiently marked. Then under Order 13, the court recorded on it that it is rejected in evidence. Endorsement is made. We know that under Order 13 that is necessary. But as the suit is on original cause of action also, if the defendant, if the opposite party, that is the plaintiff, proves that I made a part payment or I acknowledged that within 3 years, the plaintiff is entitled to get that amount. And after it is rejected, he deposes that I made 2,000 rupees, I paid 2,000 rupees towards part payment, and I acknowledge the debt on the reverse or at the foot of the demand promissory note. It was objected to by me. I said that this is a document already rejected, so it cannot be again tendered in evidence to prove the acknowledgement made in it. What will be your opinion? I will tell you, with the execution of the demand promissory note, that document became complete. The acknowledgement made by me 2 years later, or just before the expiry of the period of limitation, it is another document. It is another document. It follows that there can be more than one document on the same substance. on the same substance. Take the case I have already mentioned you, that a poor boy painted on the cow that I love you. Suppose on the other side of the cow, the girl makes an endorsement, I also love you. Then the cow makes two documents. There are two documents on the same cow. Even if the first one is cannot be admitted in evidence, the second may be admitted in evidence if it is otherwise admissible. There is no Supreme Court decision. There are only two decisions of the Kerala High Court on the point. That is 1977 Kerala Law Times KLT, 1977 KLT 448, (2004), Volume 2 KLT 1067. 1067. So there can be two documents or more, several documents on the same substance. They should be considered, admissibility of those documents should be considered separately, independently. Then, with regard to the admissibility of documents, suppose it is non-admissible, then the objection should be raised the moment it is tendered in evidence. The moment it is tendered in evidence. Otherwise, if it happens to be made part of the evidence without objection, it cannot be raised later. AR 1961 Supreme Court 1655. Yes. AR 2004 Supreme Court 4082. AR 2003 Supreme Court 4548. But if the original itself is inadmissible, marking of a copy without objection is not a ground for acting upon it. It can be raised later also. You may read AR 2001 Supreme Court 1158. Sorry, not AR 2001 Supreme Court is not a, that is not the decision. Then that is a 2017, or you can write AR decision is easy for you. AR 2017 Supreme Court 3441. Then there are two very important decisions. AR 1961 Supreme Court, that I have already given you. Then another decision is AR 1971 Supreme Court, 1070. Okay, thank you very much. Usually, I don't take classes on Sundays because it is a day for prayer for me. Unfortunately, it did not come to my notice that today is Sunday, so I agreed. And already now 7:46. Several questions were asked. I have noted it, but I think it may not be possible for me to give the answers now. If Mr. Vikas sends me these questions, I shall give the answers to the person's consent.
So what we can do is, I can also appreciate the fact, I know that we have bothered you on a Sunday, but the fact that people are still connecting, that gives that people were actually enjoying the insights on a Sunday. Otherwise, normally we say that it's a lazy Sunday. But though during these testing times, people in fact don't realize what day it is. Right? What rightly you said that you never realize Sunday. We also sometimes also never realize that on what day we fix, because on weekdays we do it at 4 o'clock, and on weekends we do it at 5 or 5:30 p.m. as per the convenience of the speaker. But they have enjoyed. But since they are an insightful session, what we can do is at some point of time we can connect, and then we can take the questions, because it will be very difficult to coordinate with the question and then answer it. And rest of the participants, those who are watching us on the YouTube, those who are watching us on the Facebook, or let's assume on the chat, they will not come to know that what was the answer to that. Except for that, we can share that answer on the WhatsApp group what we have created. Or let's assume somebody posts the questions, we are uploading this webinar on the YouTube channel of Beyond Law CLC. Then again, the question will not come. So we will try and connect it so that we can have the answers on some other way. Once we connect back on this platform, that would, I think, a better way forward. And we actually enjoyed. I think at least everybody has got the food for the brain, rest is for the stomach. Everyone has enjoyed the session the way you have put across the things. Many insights you have given us, they were all concise, precise and concise, what I can say. And
so the only difficulty for me is that almost every day I have these classes. Almost every day I have these classes. That is the difficulty for me. Okay, but I will find out some time for you. No problem.
Thank you, sir. Thank you.
We can discuss it someday. You just, if possible, you just send me the questions in advance.
Sir,
so that
I can ask the participants. They can post it on the, since they are all connected through the WhatsApp group, they can post it separately to me. Then I can see that the entire traces out can be done. I can post it. And what we can do is we can have only around 45 minutes to 50 only on the question answer session.
Right,
only for this part. Because let's assume we take another topic forward, then what will happen? These questions will not be taken because you gave them in-depth and insightful session. Then in that eventually the questions of that session will not be taken up. So we will only take particularly only the question answer session, and we will make an interactive session only for the purposes of question answers. And we will make it concise and precise for 45 minutes. So everyone, on behalf of all those participants who have participated in today's webinar, not only on the this platform, along with those who have participated with us on the Facebook Live, I express my gratitude to sir on their behalf. As they say, I can become an attorney holder for them without a virtual attorney on their behalf, that we have all actually got a good insights. And thank you for, sir, the insightful sessions. And those who want to have the updates on the webinars, they can connect us on our mobile number, what we have posted on the chat box. And for the previous webinars and the present one, we will post it on our YouTube channel. You can share, subscribe, and like that channel of Beyond Law CLC. You will get all the sessions, in fact, including the present one. Tomorrow, we are having a session at 4 p.m. with the topic is social justice and access to justice. This is by Ami Yajnik, an advocate and a member of Parliament of Rajya Sabha from Gujarat. Social justice and access to justice. During these testing times, this topic becomes relevant. So do stay connected with us tomorrow at 4 p.m. And so thank you. Though we have taken a lot of time and we have, in fact, it made inroads on your Sunday's private time, but we are all, as they say, but once it is for the larger public interest, I think in law, what we say that the private interest would be taken over by the public interest. So we all persons who have gathered up, we actually got quite
Yes.
engaged with the way you articulated it and put it across. Thank you, everyone. Stay safe, stay blessed. Namaskar.
Thank you. Thank you very much. Good night, each and everyone.
Good night. Good night.
Good night.